Victims' Rights Enforcement, the right to be present. This short video provides introductory information about the victim's right to be present and how victims' rights enforcement can shape that right to ensure victims are able to meaningfully participate in criminal justice proceedings. The victim's right to be present during criminal proceedings regarding the crime committed against them is a core right that is now recognized in every jurisdiction. There are variations on the exact language and scope of the laws providing the right to be present among the jurisdictions, however. Some jurisdictions provide for a victim's right to be present at all criminal proceedings, including trial, without qualification. Some limit the right to be present to certain proceedings, such as public proceedings or proceedings at which the defendant also has a right to be present. And some jurisdictions qualify the right consistent with what is known as the rule of sequestration. The rule of sequestration is a rule of evidence that was adopted as part of the Federal Rules of Evidence in 1975. The rule, as originally drafted, required courts, at the request of a party, to exclude witnesses from the courtroom so that they did not hear the testimony of other witnesses. The purpose of the rule is to avoid having a witness tailor their testimony to the testimony of other witnesses. In other words, to prevent witnesses from lying. All states have adopted a similar rule. In fact, the rule is so commonplace that if you attend a trial, you will often hear one or both parties invoke the rule right at the beginning, and anyone who may testify as a witness is then asked to leave the courtroom without further discussion. The problem with this rule was that it did not distinguish between types of witnesses and how being excluded might affect them. Crime victims, including family members of homicide victims, are often named as potential witnesses, and as such were commonly forced from the courtroom under the rule of sequestration. This left victims shut out of the process, literally, as the courtroom doors were closed to them. Jurisdictions enacted the victim's right to be present as a way to prevent the negative effects on victims of being excluded from the courtroom under this rule. While the adoption of the victim's right to be present was a way of limiting the application of the rule of sequestration when applied to victims, some jurisdictions have incorporated language in their articulation of the right that sounds similar to the rule. For example, in Illinois, victims have the right to be present at the trial and all other court proceedings unless the victim is to testify and the court determines that the victim's testimony would be materially affected if the victim hears other testimony at the trial. But even in states like Illinois that describe the victim's right in this way, proving the victim's testimony would be materially altered is a very high burden, and it is very unlikely that the defense or prosecution would be able to meet this burden. So, although the wording of the victim's right to be present varies to some degrees among jurisdictions, the right to be present should be regarded as ensuring the victim's place in the courtroom. Given that all jurisdictions now provide victims the right to be present, what are examples of how this right may be asserted, either by the victim or with the assistance of a victim's attorney, to help ensure the victim's right is meaningful? One example is scheduling. To ensure that victims are accorded their right to be present, scheduling the trial or other proceedings must take into account consideration of the victim's availability. For example, dates for court proceedings should avoid the victim's planned out-of-state vacations, final exam week for student victims, and special events or religious holidays. If a trial or other proceeding must occur when the victim cannot be physically present, then alternative means should be utilized, such as using virtual connections such as Zoom or a speakerphone. In today's technological world, there are many options for a victim to participate without being physically in the courtroom. Other examples relate to accessibility. The right to be present is not limited to just physical presence in the courtroom gallery. The purpose of the right is to ensure that victims are able to be active participants in the proceedings to the degree that they wish to be. To that end, the right to be present may be asserted in many different forms depending on the victim. For example, it may look like a translator and/or interpreter provided at no cost for victims for whom English is their non-dominant language so that they can understand what is being said. An ASL interpreter provided at no cost, or microphones throughout the courtroom for hearing-impaired victims. Scheduled breaks in proceedings for victims with medical needs to enable them to use the bathroom, take medications, or get up and move around regularly. A court order that the defendant's family not sit near the victims or glare at the victim. A security escort in and out of the courthouse. And a later start time for a victim with mobility issues that prevents them from arriving at a court before a certain time. rights right can also be asserted to overcome a defense request that the victim be excluded because their presence is prejudicial to the defendant. For example, a defendant may not want a victim who suffered severe visible injuries as a result of the crime to be seen by the jury for fear it would evoke sympathy and compassion, and the victim could then use their legal right to be present to object to that request. A victim's rights attorney can assist a victim with understanding all of their rights and how best to effectuate them, including the right to be present. And through rights assertion and enforcement, the right to be present can help ensure that the courtroom doors are always open, literally and figuratively, to victims who want to enter. NCBLI and NAVRA are here to help. We can assist with referrals to pro bono attorneys. We can provide technical assistance in the form of strategic consultation with victims' rights attorneys, and we can provide the training that attorneys need to help victims seek enforcement of their rights.